Good evening, everyone. Welcome to the day two of the IPR Career Summit 2024. So, this summit we have organized so that we can boost the jobs and the overall IP ecosystem in India. And right now we have with us Dr. Prachi Pandey, who will talk about the patent agent exam, its benefits, its eligibility, and how you can use it to boost your career. So this exam, for the people who have registered for the exam, it's only next month, so it's a very good time that you can interact with ma'am and you can ask her any questions related to the exam. So Dr. Prachi Pandey, she's a professor in KPGU Vadodara. She's also the deputy director of Krishna Center of Startup and Entrepreneurship. She has 18 years experience in research, IPR, and the startup ecosystem. She has a pharmaceutical sciences PhD, MBA in finance, and she has a PG diploma in patent laws from NALSAR Hyderabad, where she got the first rank with A++ grades. So she's a registered patent agent and she's a recognized IP and startups facilitator. So with this, ma'am, we welcome you to the live stream. Please, the session is yours, and I hope everyone will enjoy.
Thank you, Mr. Rahul Kapoor, for your kind introduction. So, a very good evening to all the dignitaries, all academicians, students, faculty members, patent agent exam aspirants. First of all, I would like to express my thanks and gratitude to Anindya Sarkar sir. He was my teacher who taught me the basics of pen drafting that I still applying in my professional career. Also, Turnip Innovations and Mr. Rahul Kapoor for organizing such programs for the innovators, patent agent exam aspirants, also the academicians, because we all are working over some idea, some kind of innovations, and it's somewhere our duties, our obligation to convert our innovative ideas into a working commercial product, file patent for this, commercialize it, generate revenue, and to help in the growth of GDP of the nation, as well as if we can provide employment to some others, that would be good. So, our sole duty is to convert our innovative concepts into some commercial products, and for that, patent law is very helpful. We should be well versed about the Patent Act and rules, Design Act and rules, because now these are also an inherent part of the patent agent examination. So, first of all, I congratulate you all for joining the session. The session is very open to you for asking questions. I would be more than happy to answer your queries, solve your doubts, and if you have anything to learn, if you are not a agent exam aspirant, just a student, just a faculty member who wish to know how to file a patent, how to prosecute it, and what are the consequences. So I'm there to answer your queries. So first of all, we will focus on our this topic, that is patent agent examination, that is very near, and how to make a very quick preparation, how to be very particular about answering the questions, understanding the questions. So patent agent examination, first of all, we will study what we will acquire after getting the knowledge, what is the scope of a patent agent, how we can become a patent agent, what are the eligibilities, what is the structure of question papers, what are the type of questions, and what should be the perfect answers for the questions. So let's start. One by one we will study the basics. So first of all, how to become a patent agent in India, that is a question. So basic eligibility is that we must be an Indian citizen, 21 years old at least, and must have a degree in either science, engineering, or technology from a university established under the law, under the territory of India. And such equivalent qualification means a degree is must, and we must qualify the examination, that is patent agent examination, and we must have served, or either we must have served as examiner or controller of the patents for at least 10 years. So, not less than 10 years is required, but when we apply for registration as a patent agent, then we must cease to hold any such capacity. at the time of making the application for registration. So this is the basic eligibility. Now, important is that why to choose IPR as a career option. So what will happen whenever we become a patent agent for us, for the society, for contributing to the innovators? How we can contribute? So our contribution will have several aspects, such as first of all, we can work for some law firm, we can work for a variety of industries because every industry has a separate patent department who work for the protection of their innovative property, intellectual property. We can have a in-house, means like its company or affiliates, they have a certain patent related matter, so patent agents normally solve with such matters, can like represent them for like infringement suits, even can work out how this invention is patentable or not patentable, how to like find out the novelty inside a certain innovation, how to find out the technical gaps. So all this could be a kind of counseling could be given in house. Also, patent agents can work for certain government agencies. Training and research, teaching, also this is another field. Independent practice can be done as a independent counselor. Patent attorney is another field, but for that, licensed lawyers, being a licensed lawyer is essential for becoming a patent attorney. Intellectual property consultant is a very, a very wide field in which the consultation could be given to any of the company as a freelancer. Patent analysis, this is very must because now once a patent is read through or like properly discussed, it's very important to find out where is the novelty criteria, non-obviousness, how it is industrially applicable, then how it is like different from other type of similar kind of innovations. Analysis of patent search reports, all these are the basic portfolios of a patent analyst. Also, once innovation is like their patent is filed and they are ready to be commercialized, then they have to cross a phase of technology transfer. So for TT, it's important to understand that what would be the scale up consequences. So technology transfer specialist could also be field for a patent agent, because a patent agent is not only like a files or prosecute a patents. They actually dive inside the innovation. They find out the usefulness, non-obviousness, utility, and they become master of that particular innovation. So that's why they could be a very helpful person for technology transfer. Legal counsel, they can become in-house patent counsel, patent information specialist. So there are a versatile field in different names, but the basic thing is that they should have a very deep knowledge of patent act and rules, and how it should be applied, and in the Indian patent office it should be properly represented, timeline should be maintained, and like every part of the patent must be following the patentability criteria and must not fall in the non-patentability criteria. This is very important. So while becoming a patent agent, it's becoming a very important part is like we should study each and everything in detail. But first of all, we will start from a very basic. Which act governs the patent system in India? Patent system in India is governed by Patent Act 1970, as amended by Patent Act 2005 and Patent Rules 2003. But patent amendments are being continuously done with the changing environment, and most recent being in 2024. The term comes many times. This is a very general question. Does Indian patent give protection worldwide? No. Patent protection is a territorial right, and therefore it is effective only within the territory of India. So if we file and prosecute patent in India, we can market in India only, and we can get the monopoly right up to 20 years in India only. There is no concept of global or world patent, but filing in India enables the patent to file a corresponding PCT application within or before expiry of 12 months from the filing date in India. So patent cooperation treaty, through which we can get a single filing date, and this would be applicable in all the member countries. So it should be obtained in each country where the applicant requires protection of his invention. So it's not worldwide, but yes, it can be made. Uh, One question normally students and academicians ask is like, can any invention be patented after publication or display in the public exhibition? So generally, it is not. Invention which has been either published or publicly displayed cannot be patented. So any prior use, prior publication, prior claiming, if it is done before the filing of patent, normally novelty is lost. But there is certain circumstances such as a grace period of 12 months is given. But what are those circumstances? Suppose if I have presented my innovation in a government supported exhibition, where very selected people who are scientists only are coming to me, I'm explaining to them, and they are just validating my idea with their knowledge and expertise. So in the such cases, I can say that I have displayed, but not in public, in a very like a closed exhibition, and then I can claim for, or I can request for 12 months of grace period. And these details are given from section 29 to section 34. But I normally suggest the students, all the faculty members, all the law aspirants to file a patent before displaying it in public, or publicizing it, or presenting in conference, or publication in journals. So first, we should file a provisional application if we are not ready with our innovation, get the priority date, work on it. Before expiry of 12 months, file the complete specification. Those who are already ready with their innovation should file the complete specification directly. And normally this is a very general question, that patent office and its procedures are little long, but actually this is the time length for examining it, and it is examined very thoroughly. So this is the time span actually required. But if you want to expedite it, there is provisions. So such provisions I will discuss in detail, and those who have some questions like how to expedite it, what are the forms, what are the fees, so that we can get a very expedited process of patent prosecution, we can definitely focus on that. So what we can see here, patent procedure timelines. I'm coming to the point of timelines because this is very important. Whenever we file a patent and prosecute it, it's the duty of the innovator to keep in account of the timelines, to follow it correctly, so that patent application must not be abandoned. So some of the timelines which are very important that need to be understood are these. What we can see is like within 12 months of filing of provisional specification, filing of complete specification is must. Sometimes what happens is like we are not able to complete our innovation within a time span of 12 months. We should definitely file a request of post dating. So we can post date the application to a later date, and we can get some enough time to prepare on it, work on it, and file a complete specification. But we should follow the timeline very correctly, like our application must not get deemed to be abandoned. Before that, we should file the post-dating application. Complete specifications are filed in Form 2. So this is the timeline that is very important. Once we file the complete specification, normally it takes about 18 months. After 18 months only, it gets published automatically. But for innovators who wish to get it published in an expedited way, can fill the Form 9 with a fee of 2,500. I'm talking about the individuals. I'm not talking about the companies, because individuals get about 80% of discounts in filing and prosecution of patents. For not for examination, because for examination there are certain criterias, but till publication, as an individual, as an educational organization, as a startup entity, as a micro entity, you can get such benefits of early publication as well as examination. So early publication could be done, and this it may be possible in a week or 15 days on Fridays, whenever the patent journals get published. So in a week or 15 days, your patent get published in the Journal of Patent Office, and you can see the status on the portal also. So suppose if you have filed a complete specification today and the next day you are filing a request for publication. So it could be published within 15 days. So that is the timeline. So once we file the complete specification, always understand that within 6 months of filing of complete specification, statement and undertaking of foreign application filing must be submitted to the patent office. The form specified is form 3. Why it is there? Because whenever we file in India, we have to report to Indian Patent Office that whenever we file to any foreign country, we will let the patent office know. And till date, we have not filed our patent application in any other country. So this is the declaration is given. Now the point comes, whenever our patent gets published, it will never be examined unless until we make a request for examination to patent office. So there are two modes of examination. One is the normal examination, for which we have to file the form 18, and the fees are less, that is 4,000. If we, I'm talking about the individuals, organizations, and startups. And individuals are eligible for expedited request for examination only when there is a female applicant in their team. And startups are eligible, small entities are eligible, not medium scale. So if you are an individual team, so one female applicant is must for avail the facility of expedited examination, or you should be a startup, or you should be a micro entity. So expedited examination, for expedited examination, we have to fill the form 18A and the fees is doubled. But still you are eligible for 80% of discount in the normal fees, so it is 8,000. So this, by the expedited examination, normally examination takes place in about 6-7 months. Otherwise it takes more than that. But always remember, from the date of filing till 31 months, you can file the request for examination. So after 31 months, you cannot. So this is the maximum time length for filing the request for examination. But yes, suppose if it is not possible or you forgot to do that, it can be extended by filing form 4 under rule 138. But I wish to let you know the fees are exorbitant per month. So just avoid doing it. Like do not extend the dates. Try to file the request for examination within 31 months. So this is the timeline that need to be remembered. Another thing, declaration of inventorship is to be filed in form 5, but this is the case only when applicants and inventors are different. Suppose applicant is my organization and inventors are the faculty members or the students, or in the case of company also, or suppose applicant is some other person, inventor is some other person, then in that case declaration of inventorship is must. That should be filed with the complete specification together or within 1 month of date of filing of CS, complete specification. So these things are such important things that because of such small things, sometime our patent process becomes delayed. So I always advise the innovators, like always remember which forms and the timeline and do it on the right time so that patent process should not be unnecessarily delayed. One more thing is time for applying to the first examination report. Suppose we have received the first examination report. Whenever we filed a request for examination, patent office examined it and issued a FER, first examination report, to us. Now we have to reply. In the first examination report, certain objections might be raised, such as about novelty, because a patent office examine your application and sees that if it is matching with some other kind of claim or publication or any conference proceeding anywhere. So they cite those kind of references to you and ask how you are different, how you are novel as compared to already reported prior art. Also, they may raise some objection depending on your innovation, whether it is non-obvious or obvious, whether it is not industrially applicable. So such kind of objections may be raised. So you have to reply to those objections by comparing your innovation with the already cited prior art, and you have to prove that yes, how you are novel, like in terms of novel components, affordable, economical, easy to use, You can say that it has a better output as compared to the earlier reported system. So it depends on your innovation, how you are actually properly analyzing your innovation as compared to the earlier prior art and giving a report. What is the timeline? 6 months from the date of first examination report, the um, answer should be submitted to the patent office. So within 6 months, it should be done. It is extendable by 3 months, further by 6 months by filing Form 4 with prescribed fee under Rule 138. So again, I said that Rule 138 is about the fees that are higher fees. We should avoid it. Form 4 earlier it was less. In the new amendments, it has increased very high. So try to avoid it. Try to file the answer within 6 months. Now the point comes as pre-grant opposition. Pre-grant opposition means before grant, and such opposition is just a kind of like anybody can oppose it, anyone. And opposition could be filed in Form 7A. This is a kind of notification. So this form could be filed after publication of application or any time before grant by any person, anybody. Post grant opposition is filed in Form 7 only by the person interested. Because once the patent is granted, so much of the process is done by the patent office, also the patentee. So patent office must know what is the interest of the applying person. So they must prove their interest. Like, I'm working in the same field, I have also the same company, my product is very similar. It seems that the patentee is infringing my product. So this must be the case that they have to prove it, why they are filing the post grant opposition. So it should be done in the Form 7, but 1 year from the date of publication of grant. So within 1 year, the post grant opposition must be filed. Now, another one thing is coming, the biological material. Whenever we use the biological material like the intact plant parts or anything which is a biological material, directly we are using it, we have to take permission from the National Biodiversity Authority. So NBA permission is accompanied with the patent filing process. And once such certificate we receive, we have to upload those certificate on the site of the patent office. And it should be done within 3 months from the date of filing of application. If we do not file, objection is very certain. Patent office raise objection about this biological material, and they may ask you to submit the NBA certificate. So I think we should be well prepared if we are using the intact plant parts or anything which seems to be biological. We should take permission from the National Biodiversity Authority. The point comes, now a patent is granted. We are a patentee. Somewhere we use the patent to prepare our product, manufacture our product, sell it, generate revenue. Somewhere we do not have enough facility, do not have our plants, factories. So we license our innovation to somebody else to make it, to use it. So in that case, patentee or licensee, both need to submit the Form 27 declaring the working of patent. So under section 146, patentee or licensee must submit Form 27 every 3 financial years about the use of the patent. Now the patent uses must be submitted in such a way that the product is manufactured in India. They have given employability to the people of India. Maximum portion of the work has been done in India, and currently it is meeting the demand of the public. So working of patent statement must be submitted and it should be within 6 months post period. So suppose the Form 27 has to be submitted for every 3 financial year about patent uses within 6 months post period. So once we get a patent, within 6 months post period, we have to submit our this working of patent statement. So it should furnish information relating to working of patent. That should be in Form 27. So these are some of the basic timelines that normally it should be followed. And suppose being a patent agent, it's very important to tell the innovator about those timelines and such kind of constraints. Now we are coming to the point of exam. So it's very true that once we acquire knowledge, examination become easy. So we should be read through proper interest. Patent law bare act somewhere is a looks little dry, but we have to generate interest like stories. One by one, we have to link the whole process like a full story of a patent, how it is filed, how it is prosecuted, how it is opposed, how it is taken up, and how it is being after commercialization. How also, what would be the consequences? How it has to be maintained. So we have to link one by one everything together. But talk about the structure of examination. It consists of uh, two parts. Now it's very important that Design Act is also introduced. So we have to study about the Design Act and rules also. That would be an added thing in this exam. Paper 1 will consist of 2 hours. Objective type, multiple choice questions having one or more than one option correct. It will be of total 100 marks. Paper 2 is descriptive type. That will be of 100 marks. In my opinion, along with paper 1, you have to work very meticulously for the paper 2. And now the scenario is that questions are all very logical. They are being asked with proper reasons. So try to read in a very analytical way, not just the reading and understanding, but try to analyze the things, try to link with the case study, try to go through lots of case studies that are available on the sites. Try to read even Indian Patent Act, all the court cases if possible, that are also in the public domain. So try to read those cases and try to link your act and rules with those cases, how it is being applied, and what are the findings of what are the judgments, and how these judgments are linked to the particular act and rules. So this is the only way you can really get through the exam. Now we can see Rule 110 of the Patent Rules 2003 talks about the qualifying examination. So they tells us that written test and viva voce examination is prerequisites. Paper 1 and paper 2. Paper 1 is based on the Patent Act 1970, Patent Rule 2003, Design Act 2000, and Design Rules 2001. Paper 2 is based on drafting and interpreting patent and design specifications. Passing criteria. To pass the examination, a candidate must score at least 50% in each paper. So paper 1 is 100, so minimum 50 marks should be acquired. Paper 2 is also 100, so 50 marks should be acquired. And a total of, means like including viva, a total of 60% marks should be acquired to pass the exam totally. So this is the normal framework of the examination. Now the paper looks like this. I'm just giving a glance of the paper. So this is paper 1, 2 hours. Paper, part A, part B, part C. There are 3 parts. Now 2 marks, 30 questions of 2 marks, 10 questions of 1 mark, and 10 questions of 3 marks. So normally 1 mark questions are very direct, that you can answer just by remembering the act and rules. 3 marks questions are based on logics, some kind of assumptions, reasoning. 2 marks questions are based on some kind of thinking and matching of like you can say that how the act and rules match with the findings. So I'm just discussing some of the questions and the answers of them. So first question is this. In a revocation proceeding in court, Dr. Desai was able to prove that a patent granted to one of his students, Mr. Rohan, was wrongfully obtained. Wrongful obtainment is a ground actually for revocation. So if you can prove that my friend or some colleague have wrongfully obtained my patent, but this is my own innovation. So in that case, there is a provision of revocation order and permission of grant of the whole patent to the person who is the true innovator. So this question asks about that, section 64C. So here it is written, Dr. Desai files a petition before the controller to grant the said patent to his name because his friend has wrongfully obtained the patent. So what would be the date of patent granted to Dr. Desai after such proceeding? So question is that we all know that yes, revocation proceeding would be there, patent would be granted to Dr. Desai, but what would be the date of patent? So date of patent granted would be the date same as the revoked patent. So when the day the patent was revoked, the same day will become the grant of the patent to Dr. Desai. So section 64C mentions about the revocation due to wrongful obtainment, and whenever you in detail read the rules related to section 64C, it tells about the date of the grant of patent will be the same as revoked patent. So this would be the answer. The second question, this is simple question. Miss Ragini has composed an interesting and soothing raga composition. This raga composed can be used in yoga, meditation to relax or treat patients suffering from anxiety and depression. So she would like to protect her IP rights, which is the most appropriate IP act. So whenever it is a musical, literary, or any such kind of creations, this should be the Copyright Act 1957. So this is not the trademark, this is not patent, this is not design, this is the Copyright Act. Because any poem, any kind of literary, music, anything which is like composed in such a way, but it should be fixed. Means like suppose if it is a composition singing, it should be recorded. If it is a poem, it should be written on a paper. Once we sing to somebody and without recording, we cannot claim the rights. So it should be fixed. So this was the question. Another question. I think this is a very interesting question under the non-patentable inventions under section 3. So 3E, section 3E says that anything which is just a combination is not patentable unless until such combination has a synergistic effect. So here we see that it does ask that a novel sunscreen formulation aljo is made up by mixing jojoba oil and almond oil in a certain ratio along with other excipients. Sunscreen formulation is patentable if, so always remember there should be some synergistic effect, only then it is patentable. Just mixing of components becomes not patentable. So the answer would be SPA value of sunscreen aljo should be greater than SPA value of jojoba oil plus SPA value of almond oil. So whenever we mix them, there is a synergy working, and that's why this combination is valuable as compared to individual components. And because of this value addition and synergistic action, the SPA value of sunscreen aljo becomes more as compared to individuals, and this would be the answer. So section 3E prohibits the patenting substances that are created by mixing the ingredients. Synergistic effect must be proved. So answer is C. Another question, this would be some questions from treaties would also be included here, like Paris Convention, Patent Cooperation Treaties. So this also should be would be included in the Act. So because section 135 is there in the Indian Patent Act, so PCT related or Paris Convention related questions will always be there in the objective type questions also. So prepare for that. So under the doctrine of national treatment as regard to protection of industrial property, each country must grant the same protection as it grants to its own nationals to, the question would be 1 and answer would be 1 and 4 both. Nationals of other member countries of Paris Convention as well as nationals of countries that are not party to the Paris Convention, and if they are domiciled in a member country or if they have a real and effective industrial or commercial establishment in such a country. This is written in the Act, so you can read it. 1 and 4 both would be the answer. Now I'm coming to some of the long questions. So the long questions are very interesting in this way. So before that, if we wish to solve some of the short question, we can again come back. But due to time constraint, I wish to discuss some very long question and few of the kind of analytical and reasoning based questions. So this question was the most interesting question as I observed in the patent agent examination. So when it comes to delimiting the area of monopoly claimed, the patentees were as usual between Shyla and Charybdis. If they started their claim too widely, the invention would sink in the sea or prior art knowledge. If they stated it too narrowly, it would be lost to parrots. Salman LJ has written this. Explain the above statement with best practices with regard to drafting of claims for application for grant of patent. So this Scylla and Charybdis. So Scylla and Charybdis was who were there? They were the monsters in the Greek mythology. So this is like suppose we are traveling in a ship and there is a monster and there is a whirlpool. So where to go? Both are the dangerous situations. So this is a kind of struggle between the fear and courage. So if we have, if we are too broad or if we are too narrow in drafting our claims, so we have to answer this in terms of the claim drafting and how we can make a claim not too broad, not too narrow. So in this way the answer should be there. I'm just giving you one answer, exactly how the answer should be written. So the statement, I think it is visible to all of you. The answer should be like this. So the statement by Salman LJ, it is the metaphor of Scylla and Charybdis from Greek mythology to illustrate the challenges patentee face while drafting the patent claims. So Scylla and Charybdis symbolizes two extremes, two dangerous situations. One should not claim too broadly and one should not claim too narrowly. So too broadly, if we consider it as Scylla, when a patent defines its invention too broadly, they may have a risk of encompassing the prior art. So prior art has several literatures, several patents, academic journals, conference proceedings. So if we are too broad, we may lose the novelty requirement because it may match with any of the prior arts. So our patent may deem to be invalid. This is the danger. What is the best practice? It should be very precise, very specific. We should avoid the prior art. And we should define the exact scope of the invention, our inventive step over the prior art, what are the technological gaps we are fulfilling, how our human intervention is being clearly depicted inside our description as well as our claims. So we have to say how we are better than the existing knowledge and what is the usefulness over the prior art. That need to be clearly stated. The best mode should be there in the description part. Claim must highlight the best mode of making, the best constituent, even if lot many constituents have been written in description, because sometimes what happens during experimentation, we take trials on many of the excipients components. We have the data of all of them, and from out of them we filtered out, optimized a single component which is the best. So in this way we have to write. Description must incorporate everything that we did, but claim must be clear and precise, focused on our best mode. So in this way we can avoid this Scylla. Claiming too narrow, Charybdis. Claim is too narrow, patent protection might cover very specific embodiment, just a small version. And this may happen that in today's world, whenever the patent is published and everybody is going through it, they may make a very small minor modification or improvement and can avoid the infringement. This may happen. So if you are becoming too limited, you are exposing yourself to parrots. Parrots are the companies or individuals who can exploit the idea without violating your patent. And suppose if you and them are simultaneously entering the market and they have shown a little bit more improvement over you, definitely you will lose your market. So the best practice is that claim must cover the core inventive concept without being too restrictive. You should be enough broad so that others may not come in your boundary, as well as you may not enter in others' boundary. So there should be some flexibility in practical applications, as well as we should protect ourselves from competitors who can make slight modification and can infringe our product but still cannot be called as infringers. So in this way we can make it, we should be reasonably broad, we should be very clear and specific, we should have an independent claim which write everything about the product, means at least cover everything about the product in a broad way. A dependent claim must uh, means illustrate, must describe all the components that are listed, that are described in our independent claim. But independent claim could be even one page long, that I have itself learned during my classes in NALSAR University of Law, is like from Anindya Sarkar sir, how the claims could be independent claim. That is the most important part. How to draft a very good independent claim, and how to the dependent claim would be based on the independent claim. So our independent claim could be even one page long, could be linked to each other in such a way that they shouldn't look like they are just combination or just assembly or arrangement. They should support a unit invention. All are linked to each other, all are supporting to each other. Without one component another is not possible, and that way we have to draft our independent claim incorporating each and every component with a proper linkage among each other. You can even use the Jepson claim, improvement claim, where you can write wherein the improvement lies in the improvement lies in the release property of certain substances or in the output of this. So in that way you can make it more differentiated in terms of improvement. So broad claim can lead to prior art problem, narrow claim may limit protection. Best practice is like it should be broad enough, cover the innovative concept, but specific enough to avoid prior art and ensure novelty. So in that way we can draft our claim. This why I have elaborated this question very much, because paper 2 will consist of one patent drafting question also. So this answer will help you there. Suppose just a broad claim and narrow claim example, if we can cite one example of broad claim and narrow claim. So here, suppose we have a new smartphone case. Broad claim might state that invention is a protective case of a mobile device. This general description could apply to numerous type of cases. In the smartphone case example, a narrow claim might state that invention is a protective case for a mobile device with a built-in battery and a foldable stand. This becomes too narrow. So built-in battery and a foldable stand, if it is there, if it is not a foldable stand, some other may make it, or someone else can add some little improvement, because mine is just a protective case with a built-in battery and a foldable stand. I have not written anything else, and it seems that essentially it will consist of this two only. So it becomes too narrow. So this is just for example. In WIPO, there are you can see the literatures of WIPO. There are several like you can see the claims drafting practices, but it's important to go through the actual patents. Some actual patents, if we read out and see how they have drafted their claims, granted patents, we can have an idea how the patents can be drafted. Another question. So I'm skipping this question or going fastly through it. There was one question in that Aryabhatta Aerospace Limited, I think everybody can see this, designed a new and inventive airplane wing and filed an application for the grant of patent wherein angle of attack of the wings claimed was in between 50 to 60 degree. However, during the prosecution of the said application, further research established that the best optimum result were obtained with an angle of attack of the wing between 70 to 73 degree, keeping all other design parameters same. So what would be the possible ways to protect the optimum angle of attack found later on? So this is a very important question. Why? Because every innovator, while doing the research, at a certain stage may find that Earlier, what was reported or what was claimed was not sufficient. Now I have come to a research that was better. So likewise, this innovation, earlier it was 50 to 60 degree, but later on it was found that 70 to 73 degree is the better one. So what is the option? The best option is the patent of addition for all the innovator. So section 54 of the Patent Act, somewhere, whenever such questions come, what are the options available? First, write the best option. Then you also can write about other options or other kind of proceedings, other kind of like act and rules which could be applicable here. But most important is the patent of addition. Subject to the provision contained in this section, when you can, this is the act language. So if possible, try to, because many of you may be the law students, so it may not be very difficult for you to write such kind of language, because act is written covering every aspect. So when an application is made for a patent in respect of any improvement or modification of an invention described or disclosed in the complete specification filed therefore, and the applicant also applies or has applied for a patent of that invention or is the patentee or of respect thereof, the controller may, if the applicant so request, grant the patent for the improvement or modification as a patent of addition. So it expires with the main patent. Its lifetime is the same. It is filed later than the main invention. This is the best remedy, patent of addition, you should write. Another is divisional application could also be one option, but it's not so important. Section 57 of the Indian Patent Act also allows for amendment of claims during prosecution stage of the application, provided amendment does not introduce any new matter. Then section 10 is also important. Specification requirements are also important, becomes important here. One question that is, I think, be useful for all the university students and faculty members somewhere. Mr. Chandra was doing his master's thesis at Ramanujam University of Science and Technology. He, along with his guide, Professor Chanakya, made an invention. Having no IPR policy in place, a patent application was filed and granted. It was filed, prosecuted, and granted. This is the situation. Mr. Chandra was the applicant and Professor Chanakya was the inventor. Clear? So applicant and inventors are different. Declaration of inventorship might have been filed in Form 5 and all the processes might have been followed. So this has been done. Patent is granted. But later on, university found that this patent is granted, and in university campus, this innovation took place. So there was a contribution of university also. So university said that it should be in the name of university now. So what is the prescribed procedure and documentation required for bringing the name of university as applicant in the Mr. Chandra's granted patent? Mention the corresponding sections, rules and forms. So already patents is granted. One is applicant, another is inventor, and now university's name has to be added as the applicant. So what are the corresponding forms and sections? So this becomes a very good question. We will see what can be done. First of all, request for amendment could be done under section 55. So Indian Patent Act allows for change in the name of applicant after the patent has been granted. So after patent grant also, change in the name of the applicant can be done, but there should be proper legal basis. In this case, university is seeking to be recorded as the applicant since the invention was made in course of Mr. Chandra's master's thesis and should therefore belong to the university. So there should be proper proof should be given by the university that innovation has been done in campus. Mr. Chandra is an employee of the university. He did using the resources of the university. All those things as a document must be submitted. Filing Form 16. Request for correction or amendment. The prescribed form for requesting such a change in the name of the applicant is Form 16, which allows the correction or amendment of an applicant name. So Form 16 need to be filled, and university's name and details must be elaborated in the Form 16. Another supporting documents. Now, Form 16 is a form, but what are the supporting documents that has to be filed along with Form 16? So one is the assignment agreement. Since the invention was created in the course of Mr. Chandra's research while working in the university, an assignment agreement needs to be filled transferring the rights of the patent to the university. This agreement should clearly state that rights of the granted patent are now being assigned to the university. Declaration from the university must be submitted. It should confirm its ownership to the invention under its IPR policy. Its IPR policy states that anything being done, like any innovation being carried out in the university, will become a shared property of university also. University will also hold the rights to the invention made by its staff or students during the research activities. Authorization from the university must be done. So, a document signed by an authorized person from the university, such as the chancellor or the director, authorizing the university to be listed as applicant. Submitting the application, it should be done in Form 16 with the assignment agreement, declaration, necessary documents, and upon submission, it is examined. So patent office will examine the request and documents. If everything is in order, then patent office will do the amendments. And now the university will be officially listed as the applicant of the granted patent. So this is the procedure. So assignment agreement, this become a very important document here for things to take place. Relevant section, rules and forms that have been asked in the question. So, Section 55 of the Indian Patent Act, here clerical errors could be corrected, amendments could be done, name of applicant could be changed. Rule 93 of the Patent Rule 2003, which deals with the amendment of the name of the applicant and procedure for such request making and such changes to be done. Form 16 should be used. Necessary documents outlines are given. Form 16 is there and assignment agreement. So these normally four like Section 55 and Rule 93 and Form 16 are the important ones along with the assignment agreement. So in this way the name could be changed. One very step-by-step summary also, you can summarize your answers, like once you write the basics principles, then write about the sections, rules, forms, fees, then write the step-by-step summary if some time remains. But I clearly says you that in patent agent examination we always run short of time, so be very particular in writing the answers. Keep a account of your time, always keep an eye on your watch always, and because it may happen that you may be writing very good answers for just one or two questions, and later on you will be you are running from shortage of time. So just take care about the time. That is also a very important tip for your examination. Always just be sure how much time to be devoted for each question. This is a question in which there is a kind of comparison and novelty assessment. So I think time is not much now. I can open up with some question.
Yes, ma'am. There are actually three questions.
Okay.
Maybe we take the questions now. I think it will
Okay.
be too late if we.
Yeah,
So
because this will take long.
Shreya has three questions.
Okay.
So we, if there are some people who want to discuss this question, they can also write in the chat, and we will extend the session 5-10 minutes. So no, it's not a problem. So, ma'am, first question: do we need to consider Second Amendment rules of 2004? Did they come into force?
What? Okay. Do we need to consider Second Amendment? Yes. Suppose till your examination, normally whenever patent amendment come, it is the bills is are passed, it is comes under public domain, just 1 or 2 day before exam, check everything. I have just a tip, because what happened in during my viva was just I think 3 or 4 days earlier. The amendment came in that the addition of female applicant as a eligibility for expedited examination was introduced, and that question was asked to me during exams. So I just say that amendments are like a course of patent. Just try to check it before your exams.
What topics can we expect from outside the Bare Act of Patent and Design?
Normally, the nothing would be asked in extra out of the Patent Act and Design rules. If you study the act and rules, there are some case studies. There are some kind of questions which are basically given as a kind of situations. But those situations are based on the act and rules of the Patent Act and Design Act only. They will never ask anything extra usually, in my experience. So just go through the, not only the bare act, try to read the cases. That's why I am telling you, try to read and understand the recent patent cases, because you will learn a lot of things. Suppose some situations, they will definitely normally such questions have been asked in viva in the past, but nowadays it's coming in the written examinations also. They give you some situation and try to solve it. So you can even ask some questions about yourself. Suppose if applicant is someone else, inventor is someone else, and now the inventor want to be an applicant, what has to be done? Suppose time has lapsed and now you have to extend the time. Suppose you have filed something, you want to make amendments. Suppose some kind of new findings came, then how patent of addition can help you. Suppose you have done lot of studies and filed 3 or 4 kind of innovations in a single patent application, what could be the consequences? So this may be that you patent office may say you to divide the application and file the divisional like applications. This could be the scenarios. So these are very general cases, and every act and rule are normally says about those things. But what I suggest you, study act and rule one by one only, one time, two time, three time, and try to link them together. Then it will become a kind of story that something has happened, then another some kind of objections came, then how to solve it, what are the kind of working revocation, all are just linked one by one. So try to read the bare act, but along with some case studies, not just the act. Try to make your own notes by like having some case studies added in the bare act, or you can append some pages in the bare act so that you can understand it fully.
Mhm.
What kind of a case study have to study related to design act? Okay, so in design act, basically designs are what? These are for appearance, aesthetic appearance. So suppose if somebody files a design, and the design has some kind of dots or some kind of wires or functional features being shown, so this may be a kind of objection in design. In patents we have to show all the functionalities, all the kind of like every thing that is inside. Suppose this is my phone, and I have to file a patent, I have to write each and everything that is a functional component inside this phone. But in a design we have to just see how it looks from top, bottom, right side, left side, like top side, bottom side. In this way, how does it exactly it looks? In this way we have to file the design, and it should be a clear sketches either or the clear pics. So and design act has some kind of suppose if you are making something, it should have certain use, certain purpose that need to be there. So try to incorporate. But also in design act, because there would be two act, two rules, a major question is that how to remember. So try to remember those act and rules which are application based, those you find real application in your innovation, because questions will be normally asked from those sections and rules. So try to do that.
So, ma'am, one question is, what is the difference between Form 6 and Form 16? Can we use Form 6 in the third
Okay.
question you mentioned?
Okay. So form 16, just we have seen is like it is for like amendment for an application. So amendment for an application means, like, suppose if somebody is not the earlier, it was not as a kind of in applicant, but later on he want to become an applicant. Form 6 is changing the applicant. Form 6 is also for changing the applicant. Suppose another one applicant was there and it has to be replaced by another applicant. But most of forms, two of the form 6 and 16, both are related to the change of the applicant, amendments.
All right. I think there are some more questions. Please explain Part C of Paper 2.
Part C. Okay. So part C, the long questions. Okay, I'm coming.
Do you need the slides?
No, I think this is the part C I wanted to discuss, but it will take
Oh,
a
okay.
little bit long. Part C
Okay.
is a long question. These are basically long questions, 30 marks. In that, you have to draft a patent or you have to write about, suppose this is a question that is coming in the part C. So, they have given one kind of invention in that Dr. Vaishnavi was working, and it tells about all about her invention. And then they cited two disclosures, document 1 and document 2. So D1 was showing a kind of very similar innovation as Vaishnavi's patent. D2 was also showing some similar. And patent office has asked how Vaishnavi is different from D1 and D2. So in that way, this answer could be, this become a long answer. Here you have to draft like a patent agent, like dear IP patent examiner, I appreciate. Just write a formal letter, kind of. Then write about the comparison. So novelty comparison with document 1. So it's all about that how you are saying that what document D1 discloses and how we are different in terms of purpose, in terms of data uses, in terms of communication, notification, any other. It's very subjective term. So wherever the question comes, first focus on which component they are using, what is the purpose of that, what exact modules they are using, what are their outputs, what would be my output. You have to map it. Likewise, comparison with document D2, my invention, how it is different from D2. Data collection, mechanism, analysis, prediction. It's very short time to go through it. Try to map it. Try to note down the basic important things, which looks little bit different. So try to map it out. Try to map from Vaishnavi's patent. Do some rough work and then start writing about it. Even I prefer that if you can make some table like your invention, then D1 and D2, then one parameter, how you are, how what is your invention, how D1 has proposed, how D2 has proposed, and what is the difference. So if you can make a big table also, this could also be accepted, because even in answer to first examination report, we have submitted the tables and patent controllers have accepted that. So in exam also you can make the tables. Try to like write in this way. Then first comes the novelty. Then second objection would be the non-obviousness. So how you have the inventive steps. Obviousness means similar. Means it's very obvious. Suppose somebody has make a using a like a oral tablet using some kind of polymer. Another has also made a oral tablet using another polymer, and both polymers are almost similar, but names are different. Suppose somebody is using cellulose, another is using like crospovidone or something, and the purpose of the two components are the same, but the names are different. So similarly, it's very obvious that if they are also making tablets, I am also making tablets using the similar kind of excipient. So what is my innovation? So non-obviousness has to be proved. How innovative components are added which have never been used in the past. Some innovative processes have been applied which have never been used in the past. And how suppose if I can predict something which has not been predicted by earlier innovations. So this need to be given, and it should not be very long answer. It should be very short, very crisp, and correct answers. It should be written like this. So second is about non-obviousness. Conclusion must be written at the last. Always remember, writing answer is not important. Give a proper conclusion, like how you are different, and if possible, a disclaimer at the last. My conclusions are based on the data submitted, data given, proposed methods. So give a disclaimer. So in this way, you can
Hmm.
write. So
So, ma'am,
these are some kind of long answers. Also, some claim drafting could come, like a full invention could be given to you, and you will be called to draft one independent, two dependent claims, kind of. So these are the
hmm.
long answers.
So, ma'am, let's take two last questions very shortly, since there are two relevant questions. So, patent of
Yes.
edition can be filed by a person other than the first owner.
No. 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 Only my for my invention only myself only can file the patent of addition. No any other
Hmm.
person.
Sunid Mantri asks online sources for taking mock tests.
I always say that solve the earlier question papers. This time Design Act has been introduced, but for Design Act, Design Acts are not very tough. Try to understand the basics of design, but majorly your paper would be focused on patent. Try to solve the in paper one there will not be much problem. If you're understanding act and rules and remember it, you can pass. In paper 2 you need to be very logical and reason based, and also you need to know the claim drafting. So much time to be devoted, but I just say you that you solve the earlier question paper. Try to read some actual patents granted, one or two patent granted. If you can read thoroughly and see how they have drafted the claims, you can definitely crack the claim drafting and that novelty. And if possible, try to go through the some of the documents of the patent, if possible, that are in public domain. Or if try to ask someone who has a granted patent for what documents you have submitted as an answer to first examination report, because the question I have just discussed is the answer to FER, that how we can map our invention with two other innovations. That was a question, actually, that was an objection.
Mhm.
So try to read one answer to first examination report, and try to read one full patent. At least these two things if you are doing, you can solve the part C of the question paper.
Mhm.
So
Ma'am, we
this
can send some. We can send some to the email list when we are
yes,
sending the post-event email. If you have any links you want to share, if you want to share any
yes, yes,
slides,
sure,
many people
sure,
are
sure,
asking in the chat, so we
yes,
will
sure.
add that link in a Google Drive or something.
Yes, sure, sure. I can share
So,
one or two full patent which are easy to understand for the beginners, as well as one answer to my. Even I can send my own, for which a patent has been granted recently. How we have answered the queries to the first examination report, so that can help. So yes,
hmm. All right. All right. Thank you, everybody in the chat. Thank you, ma'am, for this valuable session. Very rarely, people you will get this kind of a session, uh, which is uh, which is so focused, as well as giving you practical tips about the exam. So I think that over the years, in the next few years or next decade, more and more people will take the patent agent exam, and hence this will be a very normal thing to do for people in the in
yes.
after they have done their studies. So great, great. It's a very valuable session, ma'am, for the IPR Career Summit, and we will definitely do it again next year. And Yeah, ma'am. Any final words if you have,
Thank you
and
so
then we'll
much.
continue.
Yeah, thanks a lot to NALSAR University of Law, Turnip Innovations, all the audience. I'm always happy to help all the innovators, all the patent agent exam aspirants, because if we patent agents are more in number, we can definitely help the innovators to file and prosecute more patents. Patents should be filed correctly, should be prosecuted on time. Nothing should be delayed from our side, so that it can help the patent office also in quick grant of the patents. Thanks to all my teachers, all my audience, everybody. Thank you very much.
Great, ma'am. Thank you so much. Thank you so much, ma'am. So we will continue this stream. I will take a session on patent analytics for business intelligence. So that has been my field, and I think it adds very nicely to the IPR Career Summit, because yesterday both the speakers, Professor Anindya sir, he described so well the umbrella of activities that you can do within IPR, and I think that's the beauty of the IP field, that you don't just need to be technical, you don't just need to be business, or you don't just need to be the in the legal side. You need to have many different skills, many different uh, w- many different angles to work in the IPR field. So ma'am, I'll take the session, I'll keep you in the backstage, and yeah. All right, so I'll share my slides. I will share my own experiences, and I have designed my slides in a way that it will last about 1 hour. So I will not have separate questions at the end, but I will keep looking at the comments, every few minutes. So I will answer them as I am going through my slides. So I am Dr. Rahul Kapoor. I have done my PhD in the field of innovation management in the field of patent analytics from Finland, and that was my topic of research to basically create patent based indicators that can determine the value of patents, value of portfolios, and have some authentic measure how you can measure portfolios for strategic management. And this is what I want to share with you. I want to share the skills that you will need, what this industry is all about, what kind of jobs are there in India and in foreign countries. So uh, we will start the session. So before I share my slides, I want to ask you one question just to warm up the audience and just to warm up for the session. I want to ask you that suppose company A is more innovative than company B. Okay, so this is like, let's say the hypothesis. Company A is more innovative than company B. So what quantitative measures you can have that can prove this hypothesis? Okay, so just write on the chat. Meanwhile, I'll share my screen. So company A is more innovative than company B. What quantitative measures can prove this hypothesis? All right. So I hope you can see the slides now. So let's begin the session. Number of inventions. Very good. Very good. Likita, thank you. Shriya, IP. Yes, obviously. Number of patent filing. Yes. Very nice. So yeah, that's the question. Let me share the question in visual form to you. So company A is more innovative than company B. How can we quantitatively argue the above statement? Okay, so here the important thing is quantitatively. Okay, of course you have some subjective views. You think something. IPR. So almost everyone is saying patents, IPR, technology transfer. All right, Kirti Rani, thank you, Suneet. But everything is related to patents. I can see. So you see, obviously innovation is a very large concept, and IP is just one part of innovation. And based on your answers, actually I also agree with your answers. It is very, very difficult to measure innovation, and patents is one of the, you can say, the best measure. By definition, patents stand for inventions, and the patent data is one of the rare piece of data that is available for more than 100 countries across the globe. It is available for all the companies in the world, whether they are listed countries, whether they have uh, doesn't matter which country they are from. Patent data is one of the most accessible public data out there for the whole world. If you want to compare two companies, suppose based on number of products launched, it's very difficult to find this data. If you want to even compare two companies based on revenue, it's very difficult to find that data. Some companies are listed, some companies are not listed, some companies don't have obligation to disclose their balance sheets. So many difficulties are there when you want to measure quantitatively. So exactly, Sunid, uh, you said product sales and revenue earned. This data is so difficult to do it for companies across the globe. Okay, so very difficult to find revenue for every companies, because for patents, even if it's a very small company, even two people are there, you will find the name of that company in the patent database. Okay, you will find the number of patents they have filed, you will find all the other details about that patent. So this is why I wanted to, with this question, I wanted to reiterate this point, that how good patent data is. It is so harmonious across countries, across technology fields, across companies, across dates. Even you have more than 100 years of patent data for some offices. New product launches, very good. New product launches is a great way to see whether a company A is more innovative than company B. But again, this falls in the trap that you don't have the data of product launches, for all companies in the world in a harmonious way. So that is why patent data is considered so ubiquitous when it comes to measuring innovation. And that is why the field of patents data, patent analytics, patent statistics is there. All right. So one more point I want to emphasize about why patent data. So basically, let me go through the agenda very quickly. So today, I want to cover 4 points. One is why we use patent data. What are patent based indicators? How you can create them? I'll tell you a bit about patent databases. Okay, very difficult to navigate the patent databases that are available in the market, and I will show you some practical how a patent analytics report or a patent landscape report can be prepared. What is the workflow of that kind of a report? So why patent data? Patent data is like a crystal ball. Okay, crystal ball, it's used to predict the future. You can see the crystal ball and you can see the future, and that is the beauty of patent data. Because innovators pursue patents in expectation of future profits. By definition, someone who files a patent means to do business with it. If you see the patents of any company in the world, they are looking to build products upon those inventions. And typically in the life cycle of technology, patents come first and the products hit the market within 2 years to 10 years. Okay, in some industries like pharmaceutical, the patent comes much earlier before the product you can find in the pharmacies, because of the regulation, the testing procedures. But in some other countries, some other industries, it is very quickly. Patent is filed and a product is launched within 2 years. So most industries, you will see, when a patent is filed, the products are launched within 5 to 10 years. Okay, so that is why many analysts are there. They are reviewing patents filed by Apple, they are reviewing patents filed by Google, and they are trying to predict what new products or what new features Apple might be working on or Google might be working on. So that is how patent data is like a crystal ball where you can use it to predict the future. uh, Second important thing is innovation is closely related to economic growth. Okay, if you think about uh, you know how else would you grow your economy? Innovation is the only way how you can come up with new products, you can drive growth. So you cannot keep selling the same products or the same things forever. And that is actually seen in patent data. If you see the top 5 filings, all countries who are having a good GDP growth, it is very very correlated with the amount of patent filings. Even if you see in this picture, Japan is green, and since the year 2000 they have been kind of under recession, and that's exactly about the time when the amount of patenting that they were doing started to fall. So you can see they were even leading the United States. And for all other countries, you will see in the last 40 years, patent filings are continuously rising. Even in India now, even almost 100% increase was there in the last 2 years. This is how much filings are happening in India, and that is kind of a trend that you are going to see. So I'm going to tell you, there is this field called patent statistics, which I was working on. So by training, I have learned statistics. I have learned advanced data analytics, and I have learned advanced SQL and cloud computing. So these are the 4 areas which combined together with patent data. That's how we used to conduct our research. So patent statistics is a field of research. There are a lot of research papers in this field. They're trying to understand. Uh, it develops the use of patent information for business management, legal and technical purposes. That's the research field, and there's like thousands and thousands of research papers in this field of patent information. It simply helps to separate the wheat from the chaff, because 3.5 million patents are being filed every year. So you want to know which ones are more valuable, which ones are going to create more revenue, which companies are like the underdogs and might be doing good work. So these are all things is the responsibility of patent analysts. So this is like a pictorial definition. Not all patents filed are really valuable. So if you see, there are lots of people who invent things, but not every invention has a patent filing. And not every invention, not every patent that is filed gets granted, and not every patent that is granted is of high value. Okay, so the point is, the whole field of patent statistics, the field of patent data, is basically to find identify these high value patents. And you have host of techniques and indicators that you can use to find these hidden gems, so called. So if you have any questions so far, just write on the chat, and I'll try to take it even instantly. So why patent analytics? Because there's 3.5 million patents filed globally per year. With so much amount of data, you need good analysts, you need good data people who can navigate through these many patents and identify the right patents, valuable patents, and the patent that is going to, you can say, change the future. Most of these patents have low value or no value. That is why you need patent analysts. Patent analytics helps identify key patents, key technologies, and key companies. Like I said, it's like a crystal ball that can see the future. So, why patent data in business analytics? It gives insight into future success of firms, technologies, and industries. I'm going to give you some examples, and I'll also tell you some reasons, like why you know you might have heard that patent litigation is a very normal thing. There's a reason why companies fight for monopoly rights. Okay, because it's a scarce resource. If you can get a patent, you have some kind of a monopoly over a technical area, and this is something to fight for. And patent data also shows which companies are kind of fighting against each other, and hence it gives you a competitive landscape of technologies and industries. It's a great tool to see who are your competitors, what they are up to, and what intelligence can be drawn by the top management. Patents are considered authentic data to measure innovation and technology. Simply, even in research papers, if you quote patent data in your research paper, you try to argue your case, reviewers like it because patents are considered authentic measure of innovation and technology. So simply, I'll show you two charts. This is Google versus Apple. You can see Apple is having a much bigger history. Apple computer has been, I think, in 1997, they were creating the Apple II and all these, products. So Apple is more than 40-year-old company. Okay, but you can see they started taking patents seriously around the time when the iPhone was launched. Even when the iPod was launched in 2004, they didn't have a really big patent portfolio. But that is synonymous with the growth of Apple, right? For 30 years, 35 years, they were, they were a good company but a normal company, but now they're $1 trillion company. Okay, and you can see this in the patent filing. You can see Google, it came very late. It started in 1998, and already they were quite serious about patents from the year 2008. And this is very typical in the field of patents. An increase in patenting is a sign that a company is on a growth trajectory. You can see Pfizer, you can say that they have seen their best days. Okay, around 2004 they significantly reduced the amount of patent filing, and it is also seen in the performance of the company. It's also seen in the growth trajectory of the company. So that is why the IT companies are such a big thing. All right, so patent analytics use cases. If you are working in the field of patent analytics, you will likely support policy discussions around technologies. You will work in strategic R&D planning. Many companies in the world, they have actually a team of patent analysts in India. Okay, General Electric is there, Robert Bosch is there. Both these companies I used to consult. Their Indian, their Indian team I used to work with and help them to build reports, help them to use patent data. New product development, patent analytics is essential for even new product development. You need to continuously see what is out there. You have to continuously do search. Big companies like Apple, Google, they have a very big patent team, and they continuously monitor their competitors. Mergers and acquisition scenario, sometimes if a company wants to buy a certain technology, they look for that in patent databases. They see who are the big players in a certain field, and then accordingly find targets. So all this, I'm trying to give you examples today. All right, I'll take one question before we move to the next section, patent-based indicators. So Suneed has asked, which firms typically approach for patent analytics? Are there any Indian firms among them? So, tomorrow, a lot of in India, there's a lot of talent, okay, in the field of patent analytics. Many people have worked in the patent analytics field even abroad and then came back to India. Even Arctic Invent, they are doing consulting reports and patent analytics, which Mr. Govind Kedia, the MD of Arctic Invent, he's going to speak tomorrow. Almost every law firm has some part of their work, so apart from the legal things that they're doing, the drafting and the litigation, they have some part of their work on patent analytics. So they are kind of building reports for their clients. So almost all law firms will have some person is specialized in the field of patent analytics. I know some companies in Punjab who are only focusing on consulting and patent analytics. So I forgot the name of that company, but if you write to me privately, I will search for that company and I will send you the name. CSIR has a unit only on patent analytics. And all these big companies, General Electric, Robert Bosch, were just two examples I gave. They all have in-house teams. They have sophisticated commercial softwares. Even Tata Steel, I know they have sophisticated commercial softwares, and they have a team of patent analysts who are sitting. So you can approach either these big companies who are serious about patents. They have in-house teams of patent analytics. You can get in touch with law firms who have some portfolio of their work is related to patent analytics, or you can have patent consulting. In fact, the first 3 years of patent of Turnip Innovations, I was doing consulting. I was building patent analytics reports for some foreign clients, and that was a significant share of our revenue. So companies like us also they do patent analytics. One more question I'll just take. What skills are needed? Well, the skills are data analytics at the minimum. You need to be a good, analytical mind also. So I will share you the workflow of a patent analytics project, and you can see that every step of the workflow, you need some different skills. In my case, since I was doing research at a very raw form, we were doing a lot. You need a lot of skills in SQL databases, cloud computing, and some very technical programming skills also you needed. But at the very minimum, you need to have a good analytical understanding about industries, and also you need some skills with advanced analytics tools, like at the minimum Excel, and otherwise Google's Looker Studio, Power BI, Tableau, and so on. Being a life science graduate, I think you can enter patent analytics field irrespective of the field. So it all depends on the type of project. So usually patent analytics reports, I will also show you what are the different types of patent analytics reports, so that you can understand which kind of reports require specific technical knowledge, and which kind of reports are rather broad and at the industry level, or at a regional level, that will not require expertise in a certain field. So yeah, let's cover some basic indicators, so that you kind of have an idea about the applications of patent analytics. So one of the first thing is, it is very difficult to count patents. When you search patents in SpaceNet or in any other tool, they give you a certain number, which is like the number of hits. Now, what is those number of hits? So usually they are publication counts, okay, and they kind of overestimate the total number of patent applications that have been filed. And even total number of applications is not a very good metric of measuring innovation, but they are the easiest. And hence, for lack of better alternatives, patent count or patent application count is still one of the most important metric used across industries. But I will show you like at least two different measures. So patent count is basically the patent application count, and then there's something called a family count, which is actually a better depiction of the number of inventions that a firm is making. So those who are in the patent field will know what a patent family is. It is basically a set of patents filed for the same invention, but in different countries. They can also be in the same country if multiple divisional applications have been filed together. The whole uh, together uh, the whole number of patents, all the patents together, they constitute as the patent family. uh, so yeah, uh, so when you search on eSpaceNet, it is typically the number of documents. So whatever documents they have, they show it as number of hits. But it is a good idea to show both in the report. So I'll show you this one example. This is from IPgram, which was our own enterprise patent analytics software, and we the software was acquired in 2021 2022. And you can see here, it's a very good example why you should use both patent count and the family count in a report. Because if you see, the number one applicant, Zyleco, is filing unbelievable number of divisional applications in the United States. So you can see they have 2000 patents, but they have only 90 patent families. Okay, so that means they are not having that many inventions, but when you see the patent count, you will feel that Zyleco is a number one player. But if you see Novozymes, they have 300 patent families and approximately 1800 inventions. So this, likely the biggest player in the field is Novozymes. And again, if you see Chinese Academy of Sciences, so Chinese patents and Japanese patents, they tend to have smaller families. They patent only in their own countries, and you will see that they have a lot of big family count, but also the patent count is the same. So hence, when you see the patent, when you sort your patent, the field by number of patents or by the number of patent families, you will get different kind of intelligence. Okay. So that is why it is good to show both. And I'll also take it one step further and see that how even better indicators are there in the market that can showcase these. All right, so these are some proven patent value indicators. Forward citations, just like in research papers, if you have a very good research paper, a lot of scholars are going to cite you, right? Similarly, for patents, if you have a good number of forward citations, likely you have a very good, impactful in invention. Similarly, patent family size is one of the very, very sure shot indicator of patent value, because if a if a person or company is filing patents in multiple countries, then uh, it they are spending a lot of money. That means they are quite confident about their invention. B- Beg your pardon, sorry. So they are filing in a lot of countries, and hence it is a clear cut sign that there's a market for those inventions. Similarly, when there is opposition or litigation, it is the ultimate depiction of patent value. So yeah, so I'll show you one more chart. So I hope it's visible. It's actually the same chart, but I have added one particular measure called portfolio strength. So this portfolio strength takes into account forward citation and also the the countries in which the patent families having number of patents. Okay, so it's a research based indicator, portfolio strength. And you will see, because I added this portfolio strength, there's a company at the bottom, Teravia, okay, which has a significant portfolio strength. So if you sort this list by portfolio strength, you will see that Teravia, which was not even in the top 20, is actually one of the top 5, top 10 companies in the field of biofuels. Okay, so this is why it is important to look at different indicators, because all of them are going to give you different pieces of intelligence. So that is the job. When you are doing benchmarking for IP portfolios, you try to give as many possibilities, as much pieces of intelligence that are that can be drawn from the data. What is the current scenario of patents granted to academic institutions? Any data related to commercialization of granted patents? Uh, the data is not good, but there is some data. So in EPO, I know that when a patent is commercialized, even in India, you have certain form that you need to submit when for any technology commercialization or transfer. So somehow the applicants are obliged to submit these forms, and hence the patent office kind of has the data of the number of patents that have been commercialized. Now the point is whether this data is efficiently available or not. I know that for the European patent office, there is this kind of data, and hence it's a good way to see how many patents have been commercialized. All right, so which date to use? One of the big things in patents is that they have a long life cycle. Patents usually have long life cycles, 5-10 years. Sometimes the pendency period is there. So most patent databases are a snapshot of the most recent data. Okay, so they take a snapshot every week or every month or every 6 months, and they present you with what they have. But there are a lot of problems with this snapshot approach, because patents are usually published after 18 months of filing. So hence there will be a publication lag, first of all, in patent databases, that some patents that are already filed, they do not appear in the patent databases unless they are published. So there's an 18-month lag when the patents actually coming inside the patent databases. And to add to the publication lag, there's also a reporting lag. So all patent offices are not seamlessly giving data to the European patent office, who is maintaining a repository of 100 countries. So some countries might delay submitting the patent data by a few months. Okay, and that means those are added to the 18 months, and sometimes the lag is even like 24 months, so 2 years. Sometimes you don't see a patent in a patent database even though it was filed 2 years ago. So these are some issues with patent analytics, and these are something that a patent analyst should understand and accordingly showcase the data. So yeah, this is a typical timeline. You can see so many processes are there that it usually takes 5 years to even get a grant. So which date you should take, whether you should take the priority date, the date of filing of a patent, publication date, or a grant date. So there are many dates available in the patent databases. But from my experience, I have seen that the publication date of an individual patent, it's closest to when it is available in the patent database, and hence it's the most it's the best date to take when it comes to doing most kind of patent analytics jobs. Is it lucrative compared to a agent job? I can't say this, because it all depends. Both jobs are important, they have their usefulness. So yeah, I wouldn't say that one is more important than the other. So because it all depends on how you grow in a certain field. You also need some communication skills, managerial skills, to grow in the patent field. So either you do in the analytics field or an agent field. Both are you know so I wouldn't say that one is more lucrative. So yeah, so this is actually a very typical technology commercialization or technology management concept, which is called S curves. Okay, so typically when a new technology comes, they go through something called a S curve. Okay, and you will see that patents usually follow this exact path for any technology. So first is the emergence, when a few patents are filed for a particular field. And then when the technology is looking promising, it is having some markets, there's a very brisk increase in the number of patents filed. And then when the technology becomes more mature, most of the patent filings are done based on optimization, based on auxiliary things, not on the core technology, but on something that boosts efficiency of that technology. And hence the number of patents, although it's increasing, but the rate at which they are filed, it starts to decline. And finally the decline phase, where number of patents actually starts to decline. So so you can see this is the life cycle. And depending on which stage of life cycle you have filed a patent, your patent might be accordingly more or less valuable. So this is a example from the patent databases. In our IPgram app, we used to give a 5-year CAGR. We thought that 5 years is a very good time to compute the compounded annual growth rate, because that chunk of time is needed because of the publication lag and all the lags that you have in patent databases, to get a true picture of a technology field. So you can see the wind power industry. Actually, around 2010, it was a big rage. They were saying that wind turbines are going to be installed everywhere in the planet, and it was a very big industry. But it did not go as high as expected, because in wind turbines, because I was doing research in the wind turbine field, there's a lot of problems with maintenance. When there are offshore wind turbines, very very large wind turbines, which are in the oceans and the seas, there's significant cost to do any maintenance. If anything goes wrong, you have to send a ship, and you have to do all the maintenance and then come back. So that is why they didn't become as mainstream as people would have thought. So now, from the year 2014 onwards, you will see that a lot of patents are being filed for maintenance and these kind of activities, because the technology is already mature for wind turbines. But if you see any kind of a new field like graphene batteries, they are having still in the emergence phase, and there's exponential growth in the number of patents. So again, it's great for intelligence. It's great to showcase, in your research papers even, what is the status of a technology. So I want to say a bit about patent databases, because many people don't know the differentiations and what is available in the market. So I'll just show this a little bit, and then we'll take it. So first thing is free databases. So again, I will say that for 90% of the profiles, free databases are more than enough. Okay, eSpaceNet is a great source of data, 100 plus countries, fairly comprehensive. They have full text of many countries. They give all the information like legal status, the full document, the drawings, and so on. Google Patents, again, it's quite comprehensive. Its search is also quite powerful. It also sometimes gives results which are from translated documents. Patent Scope also has its own advantage, and Lens.org is also a great tool for analytics. If I have some time in the end, I'll show you Lens.org. So you can use it as a non-commercial user, even free of charge. So yeah, these are great tools simply because they are free of charge. It's excellent data. 100 plus countries is no joke. Great source of valuable technical information, which you are getting free of charge. It's great for idea validation. You can look up patents, look up drawings, look at the legal status, and you can look up a lot of information. So it has significant coverage, 100 plus countries. So all in all, free databases are more than enough for, I would say, most of the patent jobs. Then comes the paid databases. These some examples I have given: Derwent, Innography, LexisNexis, PatSnap, PatBase, PatSeer. So the subscription cost can be significant for these, depending on the use cases, the type of company. Even like $50,000, for one person, 1 yearly subscription can be there for these kind of databases. So they are great for professional use cases. Some of the biggest companies, they use it. So one of the biggest benefit they give is not just that they have more coverage. They claim to have more coverage. They claim to have some agreements with patent offices or some other source of data which they use to enrich the most common sources of data which are available in the market. So they have harmonized applicant names. That means a company like General Electric has thousands of subsidiaries. A company like IBM has thousands of subsidiaries. Philips, all these big companies, Samsung, Huawei. So they have maintained their own proprietary databases. So even we used to do it at IPgram. We had our own ownership database where we used to link the patent applicant names in a collapsed format. So if I have time, I will show you the sales brochure of IPgram, so you kind of get an idea what are the things that are being sold by patent databases. So you have to make one decision while you choose these paid databases. Some databases are not good for search. They are only good for built-in analytics, good for building reports, and good for sharing. But some databases, they are very good for patent search per se. Okay, like PatBase, PatSeer, these are very good for search because they claim to have more comprehensive data. They claim to have more advanced features in search, and things like patch snap in inography, they are more for analytics, more for reporting, more for data analytics, downloading, and so on. They have more coverage, according to some. They have even coverage from 120, 130 countries. So that's significant, because in eSpaceNet and Google patents, Indian data is not very good. So you have to separately source Indian data to to your own databases. The third type of databases, which is what we were using as a researcher and also in IPgram, is raw databases. Okay, these raw databases are basically PatStat is the most common database from the EPO. BigQuery has a lot of free data sets that are available, which has having global data, US data, and many other kinds of patent data. USPTO has raw files. EU IPO has raw files for trademarks and designs. And EPO also has raw files for many different kinds of legal status, and lots of data. If you just search their websites, you will see lots of different kinds of data. So typically these may be free, but usually they are also paid, because somebody is aggregating the data and creating them for download and offering some some kind of a value add. So usually they are in raw files, which is CSV, SQL, and JSON formats. It requires some database management. So to upload these files logically in a database, you need to do it on your own. So you need some programming skills and database management skills, some architecture level knowledge. But they offer great flexibility. They offer no limitations. You can work on 20 million patents, 30 million patents. They are very useful for research and statistics, because you get data in such a refined way that even the paid tools they cannot give. And the coverage varies, depending on what they are claiming. You should check the documentation and see which databases are giving what kind of coverage. So yeah, these are the three types of databases: free databases, paid databases, and raw databases that you can use. So nowadays for AI, for you need raw databases, because many of these big companies I know, like Nokia and all, they want to perform large language models, their own models, in patent data. Okay, and these paid databases, they are not allowing the use of LLMs privately in their databases. So that is where the raw databases nowadays, they are getting more and more fashionable, because now the companies can own the data rather than use databases of paid services. They can own the data, and hence have more flexibility which they can do with the data. So yeah, I'll just check the questions. Okay, do you think AI, let me see, do you think AI will take up data or roles like analytics? Well, there are always low level roles and there are always high level roles, and it's a good thing that if low level roles can be done with AI. So obviously AI is very good. If you have a very nicely prepared data set, you give it to AI, they can create good charts already. But uh, I can say from experience that 80% of the data analyst's work is actually very messy, and it is behind the scenes. Okay, what you see in a report is just 20% of the work to build the report, to build the charts. But 80% is data cleaning, is data preparing data. So it's so called the pipelines, the ETL pipelines, the extract, transform, and load pipeline. You have to transform the data to something that is useful for the user. So that is why AI is obviously a good thing, but it will, right now it is helping to solve a lot of low level work. Yeah, let's see. Workflow for patent analytics. Again, from a career perspective, from a work perspective, you will get some idea at what stage you need what kind of skills. So the first thing is to define goals with a customer or a team. This is a very important phase. If you don't understand the goals of a customer properly, you can build whatever report you want, the customer will not like it. So that is why it is very important to understand their business, to understand their expectation, to understand their industry. This itself is a very challenging thing. You need to have good communication skills. You need to really understand the needs of the customer. So this is something that it's very difficult to teach per se, but here you need to be a professional basically to really understand before you start working on any patent analytics or any data. So data comes very late. Okay, first comes dealing with customers, their expectations and their goals. Then comes the choice of database. So I told you the advantages and disadvantages of some databases. So you can see whether the customer only wants some important patents or whether they want sophisticated reports. So depending on that, you choose whether you to go for paid databases or free databases and so on. You should spend significant amount of time learning about the industry. If you are a patent professional without any specific technology orientation, you need to spend a lot of time. The more time you spend learning about the industry, the more sense you can make with the data, and that's a very important part. So here again, at the third step, I would say, don't be in a hurry to start doing data analysis. People, I myself included, have made this mistake that I want the data and I want to start doing Excel and start doing processing and so on, because we think that that's the work. But it is better to keep that part, delay that part as late as possible, because the more you understand, the more you learn about the industry, the better sense you can make with the data. Then comes building the search query. If you want to be a good patent analytics professional, you need to have a very, very good search skills. Okay, because you need the base data to perform your reports, right? If your base data is not correct, if your search queries are not correct, then it is likely that your report is not correct, or it doesn't provide the actual insights that it provide. So learning patent search is a very important skill. Turnip has a course on patent search. You can write to us, reply to any of our emails, and you can get that, like, very, very advanced features of patent search are covered in that course. Then comes the part of cleaning the data. Okay, collect it and clean the data. Before you even try to make a single chart, you should make sure you clean the data. Depending on what kind of data source you have, some data sources already provide good data, but depending on the type of data you get, you should first do sanity checks, clean the data if needed. Like, by cleaning, what do I mean? If there are different patent applicants who appear to be the same, maybe General Electric, GE Wind, GE Aviation, you want to collapse them all into something called General Electric. So that's like the cleaning part. Okay, and preparing the data. And then finally, you use a BI tool or Excel or any tool to aggregate and visualize the data. Okay, even after that, there are some steps you need to argue certain charts. There are certain ways you can present the charts. There are certain rules and regulations how you should present a chart, what you should say about a chart. So those are also by the way, covered in my patent analytics course. It's a free course, it's AICT evaluated, so it's a very, very valuable course. Please, you can check the links in the description. There's a free patent analytics course that you can sign up. And Yeah, so now about the types of reports. So this will probably answer one of the questions someone asked, uh, like uh, like what's kind of technical knowledge you need. So usually patent analytics reports are divided into four parts. Okay, one is regional innovation. Some policy level people, they want to see which countries are ahead in certain technologies. What is their competition? So that is, I call it regional innovation. Okay, we had a client like that. We were looking for you know forest products. We were looking at for different countries in the world, and these usually don't require very precise search strategy. So depending on the type of report, these are, you can say, the most broadest. You only need to search for patents in a certain geographical area and having certain technology classes. So this could be sufficient for the patent search that is involved. Okay, so you can see, as you go down, the specificity in patent search is very important. Okay, the search needs to be very precise when you are making a patent report. Some people, like, if you see the fourth step here, patent report, some companies might ask you just list down 20 good patents in a certain field. So there your search skills have to be very precise. You want to find the most important patents, and there you need to be a professional patent search. You have to be a patent search professional. So industry report, innovation report, again you need to search for patents in an industry. So again the search is made at a broad level, but when you want to search for a certain technology, you need already very good patent search skills. It is possible that in the last two types of report you need to be a industry specialist or a technology specialist in a certain area, so that you can make good quality reports. So yeah, as a general rule of thumb, your technology specificity increases, your patent search strategy has to be very, very refined. Okay, Jaimanti Pandit, can you also going to show us a patent analysis just for clarity? Actually, ma'am, in my patent search course, in my patent analytics course, which is actually there's a link in the description. I have two videos where I have actually shown how to build a report in Google Looker Studio, professional BI tool, and how to present that report. So there are two videos you can refer in that course. Because this is a 1 hour session, I just want to give a feel for the patent analytics field, so that people understand it as a career option. So that is the main goal, for my sessions, that this is looked upon like a very valuable and very interesting career skill. So yeah, best practices I'm showing you. uh, Before building any search query, learn about the industry. I already said it, but people underestimate it. They try to do the searches before learning about the industry. Always iterate your searches. Don't just do one search. Do many many different searches, and try to see how you can narrow down your results into a good data set. Prepare and clean your data. Pick few but impactful visualization. Nobody likes a patent search report which has only charts, charts, charts. Okay, you have to just pick some visualizations which are the best for the storytelling, for your client's goals. Okay, normalize your results. Again, in my patent analytics course I mention about normalizing, because to create statistically sound reports, normalizing is a very important thing. Because any new invention, suppose, will have fewer citations, fewer forward citations, because older patents have had more time to accumulate forward citation. So older patents might look more valuable when you take forward citation. So how you can normalize your results, that's a great skill. You get create more authentic reports, and wherever possible you should add context. Okay, every chart, you have to explain why a certain phenomenon is happening, not just show that this phenomenon is happening and then you don't care about it. Many people do that, and that's not going to help you in patent analytics. You should be able to tell the top management why there was a spike in patents in a certain year, or in a certain field. So you should research also the context and the background. Some common challenges: you have to harmonize applicant names. Some paid tools are very good already at this. You have to know the legal and procedural differences across jurisdictions. Sometimes when you compare two jurisdictions, for example, US has a lot of citations. In principle, they they have to cite a lot of patents in their papers, in their patents, so they put lots of backward citations. But in EPO, the inventor is not obliged to put citations in the document, so they put very few or even sometimes no citations. So that is why when you compare across jurisdictions, you should that is why also normalizing helps in that regard. Patent value is a question mark. When you search patent database like eSpaceNet, it just gives you the number of hits. Okay, so you don't know which ones are valuable and which ones are not. and, and obviously there's lack of connectivity to products. Okay, always it's not clear which patents are related to which product of a company. There have been some attempts to do that in patent analytics. We have done it manually for certain companies, but this is always a challenge with patents, because they are written in a technical way and it's difficult to showcase which technology product they are enabling. So with the remaining time, okay, we don't have much remaining time. uh, so yeah, I think I'll end the session here. So thank you everyone. Many people are saying knowledgeable session. Anand, thank you. Yogesh, thank you. Sitaramam, Jayamanti, Pandit, thank you. Very appreciate it. Nice class, says Nagar Prashant Reddy. Wonderful. Prakash says great presentation. Manmohan says great. Wonderful. I really appreciate all your comments. So these are the ways you can follow me on LinkedIn. You can write me on WhatsApp or email, and yeah, yeah. Do my patent analytics course, and it's free of charge. The link is in the description. So Kirti Rani, thank you. You're most welcome. And Great. Venkat's Sarvani, wonderful. Yeah, I'm sure you got some new insights with this session. It's a very rare piece of content. You will not find this aspect of patents and IPR in any other place. Very few people have this kind of content. So yeah, Kavisa, thank you. Appreciate it. Administrative manager, wonderful. Truly welcome, ma'am. Thank you. Great. So yeah, I will probably conduct some more detailed session. I'm inspired by so many thank you messages. So some things that I really wish to say today, I could not because of the shortage of time. But folks, tomorrow is the last day of the IPR Career Summit. So please, attend tomorrow's session. We have two great speakers tomorrow. Subhadip Sarkar, he's in Cognizant Technology Solutions. He'll talk about IPR career paths and skills as a professional in a very big firm. And we have Govind Kedia, who is the managing director of Arctic Invent. I've been in the Arctic Invent's offices in Noida. It's a great company, and they are doing some amazing work in the field of patents for global clients. So he also has a great many things. And Govind Kedia, he's a deep tech expert. So you can ask a lot of questions on AI, on software, and technology related patents. So great. With this, I'll wrap up the session now. And tomorrow, I will see you again at 5 p.m. So make sure you check your emails about the joining link. And see you tomorrow at 5 p.m. Thank you. Have a great rest of the evening. Bye bye.